Hi, this is Martha. Today's video note is actually for my colleagues in the domestic relations practice area. There is a practice that really needs to be adjusted, and I'd like to impose upon you to do this. As an estate planning attorney, I see a lot of clients come in after divorce, taking a look at their separation agreement, and many of them include a clause requiring life insurance to be purchased and maintained by one or both parties in order to dispose of any remaining obligations that might exist when one of them dies. My separation agreement has such a clause. I have seen it many, many times. One of the problems, however, is these clauses are not clear about how those payments can be or should be made. I'd like you to add 2 words, and those words are in trust. Those life insurance payments, once a check is written, are often made directly to a former spouse. That is not necessarily a wise thing to do, especially if the obligation is for child support, because child support is technically for the child. But if we hand over a check to a former spouse or former partner, that check is now subject to their liabilities, their personal liabilities. There's also no requirement that it actually be used the way it's supposed to be used. There's no fiduciary arrangement. It's just a check written to an ex, which might be okay. It's certainly okay if it's to pay any remaining obligations of a property division or maintenance. Certainly that's fine. But when it involves a child and the child's support, the better practice is to have those life insurance payments be made through a trust. And unfortunately, most of our separation agreements don't contain that language. And that leaves those of us who are doing planning after a divorce with a little conundrum, because we don't really want those life insurance payments to be made to a former spouse. For those reasons, we have just subjected it to their creditors, and there's no requirement that it be used for a child. So I've seen this lots and lots and lots of times, and the solution is just to add some few words into every separation agreement permitting a life insurance payment to be made through a revocable living trust or other trust instrument when the beneficiary is to be a child. The other thing that I have heard is many domestic relations attorneys giving estate planning or legal advice pertaining to death and disability when they are not quite sure what they're doing. So my request would be, don't do that. Refer your clients directly to a qualified and experienced estate planning attorney in your area. Get to know a few who can help and support you. That should be their next stop after a divorce, is to regroup on their planning for death and disability. One thing you might find is that some of your clients actually want to continue for their existing estate plan to function the way that they had planned before divorce. And in order for that to happen, they have to replan after divorce. You may want to find an attorney who's willing to do that. Many estate planning attorneys will not work with divorced couples or divorcing couples under the false belief that there is a conflict there. It's not necessarily a conflict. So get to know a few attorneys, make a referral right after a divorce. It should be their next stop, particularly if there are children and life insurance policies in any assets at all that are at stake. Thank you.